We have our abstract and our introduction. I will just go into our introduction, then I would leave the floor for Mr. Ogbede to take on part one. Our introduction, we'll talk about it's the concepts of property, possession, and ownership from the bedrock of legal relationships concerning things. While they are often used interchangeably in common usage, jurisprudence distinguishes these terms based on legal rights, interests, and control mechanism. These distinctions are critical in understanding the theoretical and practical application of legal rights, especially in property law. Advanced by Sir Harry Main and von Savin, property rights evolved from collective or communal ownership to individual ownership as societies became more complex. Despite the foundational role of property in law, its exact nature remains controversial and multifaceted. Excuse me. Legal philosophers have long debated whether property rights are natural or socially constructed, absolute or relative, individual or collective. The confusion between possessing something and owning it often leads to disputes in both jurisprudential theory and legal practice. This study seeks to address these ambiguities by critically analyzing the theoretical frameworks and their practical implications. The objective is to explore the conceptual distinctions and relationship between property, possession, and ownership, examine major jurisprudential theories concerning property, analyze legal authorities and landmark cases on property, possession, and ownership, and evaluate the practical and philosophical implications of property rights in contemporary legal system. So I will allow my colleague to take over the concept of property.
Yes, thank you very much. Thank you very much, Prof. Good afternoon, sir. Good afternoon, my fellow.
Thank you.
Yeah, my name is David Obeidi.
Good afternoon.
I'll be presenting the concept of property. Property is a fundamental concept in jurisprudence, which has a multifaceted idea in the sense of it's protecting and regulating the relationship between persons and things. For instance, we can say that a textbook, a fan, or a car is a property in everyday usage. However, scholars like Belt and Pachmosky have observed that property often defy exact meaning, as we know in jurisprudence. So, for this reason, much of what we are going to do is to look at the various ways in which property has been defined, especially from a jurisprudential perspective. So essentially, we are going to look at property from three main perspectives. The first being as ownership or title. Then we're also going to look at property as the rest. That means the thing itself, the thing, what we say the relationship between a thing and a person. The thing itself, what is that thing, which is the rest? And then we're also going to look at it as an interest in that particular thing. So these are the three main perspectives from which we want to look at property. So the earliest definition of property was one offered by John Cowell in 1607, where he essentially saw property as an absolute right in a thing, an absolute, like the highest right that a person can have in relation to a thing. And this reminds us of the case of Abraham and Olorofumi, where Nikitobi JCA defined this as the Alpha and Omega, that the person is an Alpha and Omega of that thing. So this is looking at property from the perspective of ownership or title in a thing. So essentially, ownership in its purest form is a right in rem, which is a general enforceable right against the whole world. And this is in tandem with Guinness's assertion that ownership is the most comprehensive right that a person can have in relation to a thing. Jurisprudentially, ownership constitutes the ultimate legal authority over an object, distinct from mere possession or limited interest. This was the idea of Guinness when he wrote on rights in rem, a new approach. Um, we can also look at property as okay. So there's another important thing that I need to mention, which is that property in this sense of ownership can be seen in Section 20 of the Sale of Goods Act, where it is seen as a right that it passes with the risk, res perit domino, which means that risk follows ownership. So people who are conversant with commercial law, when they make reference to ownership, it is in this sense. When they make reference to property, the property in a thing has passed. They are actually referring to property in the sense of ownership of that thing. Then let's also look at property as a rest or the physical thing. So this is the second connotation. The thing itself, it may be corporeal or incorporeal. As corporeal, it means maybe like a land or a car. While incorporeal, those are things that they're not tangible. That's like patent or a debt. So property can be seen in that sense. For instance, when we talk about um, intellectual property. Now, we can also look at property as an interest in a thing. So this is the third sense in which property can be conceptualized. So in this sense, it tends to denote more possession than ownership. And an example is in the case of Donald and Suckling, where the pledgee had no title but retained a possessory lien over the pledge chattel until the debt was discharged. So we will note that much of the arguments among scholars have revolved around property as ownership or possession, which my colleagues are still going to throw more light on. And of course, they will look at the ideas of people like Salmond and then scholars like John Locke, who looked at it from a natural rights theory. So we don't go into repetitions. I will allow them to touch on that area. But also, I want us to also note that property can also be classified into personal property, where you have choices in possession, choices in action. Particularly with respect to choices in possession, they refer to those tangible physical items that are capable of being possessed and, of course, transferred by simply delivery. While choices in action, of course, they are intangible rights that cannot be physically possessed. The locus classicus in this regard is the case of Tolkien and Magi, where a choice in action was defined as a non-legal expression used to describe all personal rights of property, which can only be claimed or enforced by action. Now, based on the current trend, we know that today cryptocurrencies and blockchain-based assets such as NFTs, they possess fresh jurisprudential questions about the nature and classification of property, especially when these assets defy traditional notions of physical possession. Um, in Nigeria today, under the ISA 2025, cryptocurrencies are now legally traded and invested in. And of course, I think they can be defined as properties, so to speak. Property can also be classified as public and private property. For public property, we are looking at properties that government has interest in, such as land. For instance, Section 1 of the Land Use Act vests all land in a state, the state governor. And while those who make use of this land, they are more or less the tenants of the governor. Private property are exclusively owned by individuals who are not government. They are private entities. They are not government owned. With that classification, I've come to the end of discussion of property. I would now hand over to my colleague to discuss possession. Thank you very much, Prof.
Thank you. Good evening, Prof. Good evening, everyone.
Yeah,
My
good
name is
evening.
Yes, sir. My name is Elebute Seriki. I'll be discussing the concept of possession. Possession means custody or control. And we can as well say that in the parlance of jurisprudence, it is referred to as physical control and legal recognition of an object or property, encompassing both the actual exercise of control and the intention to maintain that control. According to Salmond thought of school, it defines possession as continuing exercise of a claim to the exclusive use of an object. Also, Holland, in the school of thought, also states that possession is the physical control over a thing with the intention of holding it to the exclusion of others. So now we are going to the theories of the possession proper. The theory of possession has been explained and analyzed by various schools of thought and thinkers. One of them is Savini theory of possession. According to Savini possession, it is the physical power of exclusion, protection of possession, which is a branch of protection to the person and a thing he owns. Freedom of will is the ground for the protection of possession. So Savini, in the context of Roman Poe, said that there are two elements to possession, which are corpus possession and aminos domini. He also defined, excuse me, sir. He also defined corpus possession as a compelling physical control of objects. Also, the quick physical power is not important to proceed the possession as was required to offer assent to it. And proceeding with possession depends rather on the constituent intensity of duplicating the first relationship freely. Why he defines an animus domini, which means to be the mental element or the aim or intention to hold the possession as proprietor against all things. So I would like to move. Hello, sir.
Well, yes, go on.
Yes, sir. Thank you, sir. To his hypothesis, disclosing the respect to why the occupant or a borrower or an operator had no possession of the article or object or loan or endowed to manage them according to Roman law. They had no animus domini. I'm sorry for for bastardizing the Latin maxims. They had no amino domini as they did not plan to hold the object on their very own rights. As he has stated that, he has failed to state the abnormalities and recommend that there were the cases of derivative possession. In prima facie case, evidence of ownership, meaning that the person is in possession, is presumed to be owner unless proven otherwise. This presumption is crucial in legal disputes as it places the burden of proof on those challenging the possessor's rights. According to Ll.M theory of possession, it defines possession as the de facto exercise of a claim over a thing, according to Roman law. It supports the title of ownership. The possessor of a thing is presumed to be owner. Long enjoyment of a property creates ownership. This is known as prescription, hence possession in nine points in law. According to Ll.M theory of possession, it was towards as a sociological legal scholar. He offered the conversation starter to why Roman law secured possession by method for bidding. He says that it was concurrent to profit the proprietor by ensuring the holding of the property, though setting them in the invaluable position of respondents in any activity as to the title. According to John Henry, what is vital is the consciousness of thing which can offer possession to an individual. His methodology is said to be more common sense than Stevenin theory of school of thought. He gave a utilitarian meaning of possession, while likewise the ideal of possession may change significantly in various cases of law. We also have Ll.M theory that it refers to possession as reality which are required to start possession and to gain it. It establishes possession can be concentrated just when possession is first picked up. These relations and its aim are certainties of which are in pursuit. Ll.M recommended that English law does not require the aminos domini element. However, only the aim to avoid others. For example, sir, the inhabitants wants not to hold and proprietor of a land. However, just to bar the landowner. Ll.M proclamation is regardless equivalent to Stevenin appropriation of corpus and aminos. Now, I'm moving to types of possession. We have possession in fact and possession in law. The possession in fact is the physical possession of a thing, which is called possession in de facto possession. It is also known as de facto possession. It indicates physical control of a person over a thing, regardless of the legal recognition. While possession in fact is recognized and protected by the law, which is called possession in de jure possidendi. It is a possession in the eye of the Lord. In the eye of the law, it may not always coincide with physical control. Now I'm moving to elements of possession, which is corpus possidendi and aminos possidendi. I think not to waste the time of the court, corpus possidendi is the same thing as possession in fact, sir. Sir? Sir?
You said
Hello,
you don't
sir.
want to waste the time of the court.
I'm sorry.
I said you said you don't want to waste the time of the court.
I'm sorry, sir. Not to waste the time of the class, I'm prob. Corpus possidendi is the same thing as possession in fact, which I refer to as the factor possession. It deals with the physical possession of a thing, as I've earlier said, while amino possidendi means intention to possess a thing. So I'll move to distincts between ownership and possession. I'm making reference to land law now as my example. Ownership is an absolute right of a property or a thing, while possession is evidence of ownership. Ownership is the factor which deals with physical things, exercise of rights, while possession is de jure recognition of claims. Ownership is related to rights, but possession is related to a fact. Also, ownership includes possession, but possession does not include ownership. I will move to comparative analysis and global perspective of possession in Nigeria and other jurisdictions. The concept of adverse possession is not unique in Nigeria. In common law, jurisdictions such as United Kingdom and the United States, similar principles apply, although with varying statutory period and legal nuisance. However, some countries have chosen to abolish or reform the doctrine altogether. For instance, Singapore has eliminated adverse possession claims, reinforcing the principle that registered landowners we should not lose their property due to inaction. But in Nigeria, as a common law jurisdiction, we likely stick with this principle of law as against the global shift. Conclusion, sir. The concept of property has been in existence since the existence of humanization, though from a piece of brick to an idea behind products, property as a concept has developed in an unanticipated manner. The research being done in the field of property law makes it a dynamic concept which continue to evolve in the years to come in the nearest future. So this will be the end of the concept of possession, sir. I would like to hand over to my colleague that will be dealing with the concept of ownership. Thank you, sir. Thank you, everyone.
Okay.
Yes, sir. Thank you so much. And good evening, Prof. Sir, and good evening to the whole class. Yes, sir. Hello, can you all hear me, please?
I can hear you.
Okay, thank you very much, Prof. So my name is Alara Oluwasegun. I'll be taking it up from where my colleagues stopped. So I'll be talking on ownership. And according to Professor Diaz, ownership is the aggregate of certain jural relations involving claims, duties, powers, immunities, and liabilities concerning the thing owned. Now, the term ownership is derived from the Latin word own, and this means to have or to hold a thing. One who holds a thing as his own is called the owner and will have right of ownership over that particular thing he's holding. So from this standpoint, we can say the term ownership literally means legitimate and absolute rights of a person over a thing. Ownership is the state or fact of exclusive rights and control over property, which may be an object, land or real estate, or an intellectual property. It involves multiple rights, collectively referred to as title, which may be separated and held by different parties, not necessarily one person. Now, one can transfer or lose ownership or property by selling it for money, exchanging it for another property, giving it as a gift, misplacing it, or having it stripped from one's ownership through legal means. And such legal means could be one, through eviction, two, through foreclosure, three, through seizure or taking. Ownership is self-propagating in that the owner of the property will also own the economic benefits of that property. That means ownership is self-propagating in that the owner of a property definitely would have the benefits, the economic benefits emanating from that particular property. At this point now, we'll be looking at ownership theories. We have various jurists who have defined ownership in different ways, and all their definitions accept the rights of ownership as ownership of the complete or supreme rights that has been exercised, that can be exercised over anything. So in the essence, virtually all the jurists in question here, one thing is very common among them, and that is the fact that they all accept the right of ownership as ownership of the complete or supreme rights that can be exercised over anything. Now, we'll first look at the Austin's theory on ownership. According to Austin, ownership is a right over a determinate thing, indefinite in points of the user, unrestricted in point of disposition, and unlimited in points of duration. So from this definition of Austin, we'll notice that he focuses on three things. One, and the first one is indefinite user. Austin's theory focuses on indefinite user. Then it focuses on unrestricted disposition, and then it focuses on unlimited duration. Now we'll look at the first one, indefinite user. It means that the owner of the thing is free to use or even misuse the thing in the manner he likes. The use of the word indefinite, however, here has some restrictions in that one, the owner can be restricted by agreements or by operation of law, some of which are one. The owner of a thing cannot be allowed to use the thing in a manner which will be injurious to others. This is expressed by the maxim sic ut tu ut ali nom non laedas, which means that so use your property as not to injure your neighbor. And also, ownership may be subject to encumbrance in favor of others, in which case the power of the user of the owner is curtailed by the rights of encumbrance. And also, the state officials have a right to enter the owner's premises in pursuance of a warrant issued by a court or for any lawful purpose. So yes, the indefinite user factor here has some restrictions as well. Then the second point the Austin theory focuses on is the unrestricted disposition. And here, the right of disposition implies the right of alteration, destruction, or alienation of the property. According to Austin, an owner of a thing has unrestricted rights to dispose it of in any manner he or she deems fit. And the third one the Austin theory focuses on is unlimited duration. According to Austin, the time of ownership is unlimited in point of duration. The right shall exist so long as the owner and the thing exists. It is a perpetual interest which shall devolve upon the heirs of the owner after his death, but the right shall not be extinguished. So under the unlimited duration, according to Austin here, the right shall exist with the owner in perpetuity. That is, it doesn't leave him until he dies. And even after he dies, his heirs can still take possession of that particular thing. And now we look at the Salmon's theory of ownership. According to Salmon, ownership denotes a relation between a person and the right vested in him, which means a man owns what a man owns in all cases a right. It consists of complex rights, all of which are rights in rem, being good against the entire world. Now, we would now look at Holland's theory of ownership. According to Holland, he defines ownership as a plenary control over an object. And according to him, an owner has three rights on the object owned, which are possession. It denotes control over material object and can be lost by lease or mortgage. The second one is enjoyment. It implies the right of the owner, however limited, but it implies the right of the owner, however limited by the rights of the states. So in this particular point, the enjoyment implies that the owner has a right. However, that right is limited by the rights of the state, which I'm inclined to believe that we are conversant with the Land Use Act by virtue of the fact that all lands is vested in the governor of the state. Yes, the owner might have a right over that particular property, but the unexpired residue is what he has, the 99 years given to him by the governor. So the governor can at some point decide to revoke it. But obviously, revocation of that right of occupancy comes with some conditions. So that is what I think Holland is trying to say here, that a person actually owns a thing and can enjoy it, but it's still limited by the rights of the state. And we now look at the Marxist theory of ownership. And the Marxist theory of ownership is quite interesting because it deviates completely from the three positions I just mentioned. Now, the Marxist theory of ownership states that this theory draws attention to the evil role ownership has played. So from the Marxist standpoint of ownership has played a very, very evil role. And why is that theory sought? He said it begins with an individual working with its own tools and raw material. That is, an individual starts with working with his own tools and his own raw material. Later, the profits accumulated through trading manufactured products elevates the owner to the position to provide tools and raw materials. So if we look at it from the first stage, it says that the owner, the individual, works with his own tools and raw materials. After a little while, he gets to the point whereby he now becomes an owner be in a position to provide the tools and raw materials. Now, when he's now in that position, he now gets other people to provide the labor. He is not the one doing the labor now. He gets other people to provide the labor. The manufactured products, however, remain in his ownership. So other people do the labor, but now the manufactured product stays in his own ownership. It is the concept of ownership that enables the exploitation of workers. So according to the Marxist theory, this particular concept of ownership enables the exploitation of workers. Ownership of the means of production, tools, and raw material become a source of power over persons for a private profit. This promotes inequality. So according to the Marxist theory, ownership promotes inequality. Why? Because using the power of dismissal and threat of unemployment and consequent starvation, the employer is able to dictate unfair terms of service. The owners of the means of production become industrial commanders, wielding enormous powers that strike at the fundamentals of society. So if we look at ownership from the Marxist standpoint, yes,
hello, are you
sir.
Are you speaking to this paper or teaching us? Because even in your paper, I can see that what you wrote on Marxist theory is very short, but your explanation is we're in postgraduate class. Just talk to us briefly about. Do you understand?
Okay, sir. Perfectly, sir. Thank you so much,
I saw
sir.
you spent just one paragraph, and then your explanation is like going to 2 pages.
My sincere apologies, Prof.
As we move on, we may not have that time. We may not have that luxury of time.
Thank you so much, Prof. Sir. Yes, sir. Thank you so much, Prof. Sir. Yes, sir. Thank you, sir. So now we move to kinds of ownership. So what kind of ownership we have? We have corporal and incorporeal ownership. And corporal ownership refers to the ownership rights of tangible physical objects that can be seen, touched, and physical control, such as houses, vehicles, lands, and furniture. Then we also have.
I'm not hearing you.
Trust and beneficial ownership. One person, which is known as a trustee, for the benefit of another person. Okay, sir. Yes, I said we have trust and beneficial ownership, sir. Kinds of ownership. Can you hear me now, Prof, sir? Yes, sir. Thank you, sir. So we have trust ownership, which arises. Yeah, thank you so much, Prof, sir. Which arises when legal ownership of property is held by one person, that is the trustee, for the benefits of another person, that is the beneficiary. So in this instance, the trustee is bound by law to manage and use the property in a way that benefits the beneficiary, but they do not have personal rights to the profits or the use of the property. Then we have legal and equitable ownership. Now, legal ownership refers to ownership recognized and enforced by the formal legal system. It grants the legal owner full rights to the property under the law, such as the right to possess, use, or sell it. Then we also have vested and contingent ownership. Vested and contingent ownership refers to ownership that is completely unconditional. The title holder has full present rights over the property without any condition of future events that might affect those rights. Then we also have sole ownership and co-ownership. Sole ownership occurs when one individual holds all the rights to a particular property. The sole owner has full control and authority over the property, meaning they can use, sell, lease, or transfer the property in question. However, co-ownership, or better still put, joint ownership, exists when two or more individuals share ownership of the same property. Each co-owner holds an interest in the property, which may, but in some instances, may not be equal and has rights proportional to their ownership share. Now, at this point, we'll take a look at the modes of acquisition of ownership. How does one acquire ownership? Under modern law, ownership can be acquired through two main modes. The first one is the original mode, and this arises from the independent actions of the acquirer, and it includes the following types. We have the absolute mode. Ownership is acquired over an object that was previously ownerless. And also we have the extinction mode. Ownership is obtained by extinguishing the previous owner's rights through an independent adverse act. Then we now have the accessory mode. Ownership results from accession, where an addition to a property leads to the acquisition of the owner. And the second mode is the derivative mode. Here, ownership is acquired from a prior owner through various methods, including title of the prior owner. Ownership is obtained through an agreement or bilateral act with the previous owner's consent, such as through assignments or grants. Then we also, under the derivative mode, ownership could be acquired through purchase, and ownership could also be acquired through, maybe derived through a will as established by various judicial decisions. For instance, a husband cannot claim ownership over his wife's property after her death if she bequeathed it. Then we also have ownership being derived through gifts. Then we have ownership being derived through succession. Ownership is acquired through inheritance. Upon the owner's death, inheritance rights pass to legal representative, whereas certain personal rights may extinguish. Succession may occur through intestate or testamentary process. So at this point, I will leave it to the capable hands of my colleague to round things up. Thank you.
Thank you, Prof. Thank you, my colleagues. So I would go
3.4 is very important too.
Sir.
The role of legal system in determining what can be owned and what group of rights amount to ownership. Can somebody talk to 3.4?
Okay, sir. So point 3.4 says what can be owned and how is it determined by respective legal systems. Now, so to answer this question, yes, sir. So to answer this question, it is to take a trip in history and analyze ownership at various legal systems. Then, so here, we look at the concept of ownership of both legal and social interests. Not only have courts utilized the idea in such a way as to give effect to view of exchanging individual and social interests, but so great are its potentialities that in recent times it has become a focus of governmental policies. Ownership consists of an innumerable number of claims, liberties, powers, and immunities with regarding to the thing owned. Little wonder some jurists analyze the concepts out of existence ad infinitum. It is impracticable to talk of ownership devoid of claims of the owner. Such a view is undesirable and inadequate. So for the connotation of ownership does not correspond simply with its component elements any more than the word thing connotes just a group of individuals. Another reason is that the various claims constitutes rather the contents of ownership than ownership itself. A person may part with the claims to a greater or lesser extent while still retaining the rights of ownership. Also, it is also misleading to talk as if ownership means only the claims. It will be truer to say that a person is entitled to these claims by virtue of the right of ownership. Ownership as an asset has value apart from its component claims. And lastly, ownership is an institution that is generally recognized. So it is not surprising that certain features are shared among various legal systems. Now, looking at it from the English perspective, ownership in English law has to be approached from a historical standpoint, for its evolution is bound up with the remedies that used to be available. The peculiarity of English law is that it did not achieve an absolute ownership as did the Roman law. The idea of ownership did not evolve in the same way in relation to land and chattels. Land used to be held in a feudal tenure, which has a hold, which has this holding known as seism, which originally meant no more than possession and denoted the state of affairs that made enjoyment possible. So here, if a person's seized was dispossessed, he has to rely on his seism to get back on the land. And for this, the old remedy was the writ of right, in which success depended on the claimant, being able to establish a superior right to that of the possessor. And also in the reign of Henry II, the possessory seizures were introduced, and this led to the shadowy distinction between seism and possession. So between the respective basis of the writ of rights of the possessory assizes. This, however, was very, very unsure, since even possession was carried with it the right not only to be in possession, but also to regain it if dispossessed until someone else proved a better right to it. At the earlier times, there was no talk of ownership as such. The earliest mention and the use of the word owner, according to Marsland, quoting Dr. Murray, occurred in 1340 and ownership in 1583. A further step in the differentiation of seism and possession came with the tenants for a term of years, whereas seism was protected by the writ of rights. The tenor's right was protected by a form of trespass, the ejection famine, ejection of a farm, a writ or action of trespass to obtain and return of the land or tenements to a lessee for a term of years that had been ousted by the lessor or by a reversioner, remain demon or stranger. So his interest was not seism, it was styled possession, which sharpened the contrast between seism and possession. So with time, new remedies emerged and replaced the old ones. Trespass came to protect the possessor, and ejectment was available to a person out of possession who would prove a better right to possess than the possessor. These were based on the old principles, so much so that even in modern law, there are many cases which show that ownership of land is only a question of better rights to retain or obtain possession relative to the other party to the dispute. Holdsworth, however, argues that the action of ejectment introduces a new idea. He said that in his action, a defendant in possession could set up a jus tertii, right of third party, in answer to a plaintiff's claim to obtain possession, i.e., a superior title in a third party. Therefore, according to him, a plaintiff.
Okay. Hello.
Yes, I'm with you, Prof. Sir.
To that topic. So,
yes, sir.
So let's go to part 4.
Okay, sir. Thank you, sir.
We're going to talk to us about the evolving trend.
I am, sir.
Okay.
Thank you, sir. Thank you, my colleagues. Now, owing to the technological advancements, societal changes, the world being a global village, there are certain evolving trends that has affected property ownership and possession. Number one, we'll be talking of property as a fundamental right. By virtue of Section 44 of the 1999 Constitution, as amended, property, we have the rights as citizens to own property. However, in the past, the courts does not really see it that way in Nigeria. They kind of take it as a land matter, that every land matter should go to court without protecting the rights of the citizen as enshrined in the Constitution. But recently, in the case of Niger Delta PH Co. Limited versus Michael, the Supreme Court held that as a property owner, you have a right to come under the fundamental human right. It is a right that has been guaranteed under the law and it can be protected. Depending on the circumstances, landowners can come to court to enforce their rights if such has been breached. In this case, where the governor revoked the land and refused to pay them their compensation, the court held that they have a right to come to court to seek to protect that right which is guaranteed in the Constitution. This is it is a new trend which shifted from the former position in the case of Sokoto local government. 2012 decision is contained in our paper. Like the theory of the natural law school, Locke has consistently stated that the right to own property is inherent, and that it is not given to us by the state. It is a right that we are born with, which is in contrast to the positivism law school, who believe that better believe that it is the states that gives you that right. And if you look at the Land Use Act, you would find out that we are almost tinted to that angle where we are just do we say we are just in between licensee and mere owners, because the government can revoke that land at any point in time for public interest or pressing issues as you may have it. But Locke has stated that this right is inherent and that it is not given to us by the states. I would say that if we look at Article 17 of the Universal Declaration of Human Rights, 1948, and Article 14 of the African Charter on Human and People's Rights, this right also provides that we have a right to own property. So with recent cases now that is ongoing nationwide, we'll find out that the courts now in Nigeria, they are now protecting this right. They are now saying that the right to own property can also be brought under the fundamental human rights of enforcement rules. That is a very recent case. It's a 2025 case, so it is a new trend, and it is a way ahead to also protect our rights as citizens to own property. Then we look at the recognition of digital assets as property. Unlike in the past, if you tell people that I have cryptocurrency or NFTs, we'll just look at the person like, what are you saying? Many of us see it as a waste of time or something. But now with the recent cases, we'll find out that the courts are recognizing digital assets as property. So you can say that you own property, and it is digital property. So just like you say, I have a house, you can say I have so thing in my wallet. So this is being recognized. Although the president passed yes. Although the president recently passed the bill into law, where SEC has defined cryptocurrencies and all that as a part of digital assets, but we don't really have much cases in Nigeria. But it is also a recent trend of recognizing digital assets. Then we have adverse possession. Well, this has been on for a long time in Nigeria, where although you are not the owner of the land, but you have been in possession without the consent of the owner, and you have that is not the owner that puts you there. That's why it's adverse, and you have been able to perform rights of ownership, and you have done a lot of things. After 12 years, the owner cannot come back and say, I own this land. The statutes of limitation will bar that owner. It will stop the person, the presumed owner, from claiming such rights. A lot of people had really frowned about this theory. However, it is a way to encourage people to be vigilant, because the law believes that you should not sleep on your rights. They say equity aids the vigilant. So you don't sleep on your rights and wake up one day from nowhere and after the person had developed the place and come to claim ownership. So the doctrine of laches and acquiescence also supports this adverse possession where the supposed rightful owner cannot come back and now say I own this thing. So it is a trend because a lot of people who are supposed to be owners of property can no longer claim them because they are barred from doing so. Then we have technology advancements, that's blockchains. We have that in various countries now globally. Even in Nigeria, we have the CBN, the SEC, even customs. We have several times where you buy a car or you register it and everything can be traced. So it's a way of protecting one's property now. So blockchain has really come to encourage and to put away fraud, to encourage rights to property globally. Then governor's consent and land transaction. We, unlike in the case of Savannah Bank versus Agilo, where the Supreme Court said that you cannot sell your property to a third party. You cannot transfer interest without the governor's consent. The Supreme Court has moved away from that position now in the case of Yakubu Ibrahim and others versus Simon Obaje, where the court said that yes, the court is recognizing communal ownership, that you can do that without the governor's consent. So um, you can alienate your interest in whatever you have in that property to another person without having to wait to go through registration or carrying from one where we have these backlogs of registering title and all the whole problems before you can then properly sell your property. So it is no longer so. It is a new trend now that you can conveniently um, sell your properties now without having to go through all those rigorous exercise of having to perfect the title. Then we have revocation of land titles. Well, this is a very especially in Nigeria by virtue of Section 1, the governor of a state owns all the land in that state. So for public interests, it can be revoked, but the court is saying that the person will be compensated. We know what is happening now in FCT, where if you don't pay your ground rates, Wike will just come over there. So it's now a trend now that though you claim to own your property, but you are still you are still like a tenant to the governor of that state or the minister of the FCT because you have to pay your ground rent, or the governor can revoke your title, and at the same time the governor can revoke your title for public interest. So this is also one of the trends in lands, both in Nigeria, especially in Lagos State. If we go to those islands area where they go and demolish it and they say the road pass here, this pass there, it is something that has been happening and is still happening as far as property ownership is concerned. Then in our conclusion, we talk about all the theories that have been discussed slightly, that though property ownership and possession are being used interchangeably, they are distinct. Even though they are kind of connected, they are distinct, and the court should find a way to educate or create more awareness I will use that word. The court should not confuse us. If you check some of our law reports, possession, it's almost defined as ownership. Ownership is almost defined as possession. These things are distinct, and this jurisprudential paper have been able to explain to us that they may be used interchangeably, but they are distinct from each other. The people should not confuse them. Then we also talked about in our recommendation, we talked about legal pluralism. Nigeria being a very peculiar country where we have both customary law, we have Islamic law, and our general law. It's good for us to recognize the fact that um, people can own land customarily, which the Supreme Court now is now tinted towards that angle, like in the recent case I just cited. So Nigeria is a peculiar state. You cannot just ignore that fact that you can customarily buy land. Like in Abuja, I know that unlike in Lagos here, where you have to go to the state land registry, in Abuja, you can go to their local governments to register your land. Their chiefs there can properly give you title. I was so surprised when I saw that, but these are things that are happening. So it should be encouraged and recognized. We should not push away our backgrounds or old system because of do I say the new trends? Then judicial clarity and codification, like I said, well, the court should adopt a consistent standard in distinguishing ownership and from possession, so that people are very clear. There are clear terms as to their definition, where you're talking of I own this or I'm in possession of this. A layman should be able to understand that there are two different things. Then equity and access to property as a right. We have a right to own property, but we will agree with me that some people cannot afford to own a property because of the economy. So, like inspired by the sociological and Marxist perspective, government should promote equitable access to property where it is not just limited to the rich or the average class, so that it can be easily accessible. We know about rent now. We know about the way it is like in Lagos State, where I could say that you just have to be rich to be able to rent an apartment now. So the government should look into things like this to create some form of respite for citizens. Then legal reforms. There should be updates on property laws to address contemporary changes. I believe that Nigeria is trying, Lagos is trying too, but there's still room for improvement to do that. Then public awareness, so that a layman understands what their right is. And how they can go about it if it is infringed upon. Some people will not know that you can actually go to court to seek redress, even if it's a property matter. You can go to court to seek redress that your right has been violated. You know, some of these people that they demolish their houses, some of them have not been paid till today, but they don't know how to go about it. So there should be a public awareness in this regard. Then international corporations, just like we mentioned with all this, the UDHRO and the African Charter, we should try to really follow them and incorporate them properly into our system, not picking and choosing the part that favors us and then leaving the part that doesn't favor us. We should embrace them in total. And we should also cooperate with international bodies to be able to enhance our rights. Thank you, sir. Thank you, Prof, sir. Thank you, colleagues. That will be all for our presentation, sir.
You're welcome. It looks like it's not going to be Ll.M jurisprudence we are doing. It's going to be Ll.M ownership. in comprehensive manner. We gave you time to discuss like we are from Ll.M jurisprudence to Ll.M ownership. So I won't say that much. What is the title of the next seminar paper? Class captain. What is the title of the next seminar?
Good evening, sir. Good evening,
what?
Prof. My name is Oluwatosin Adebowun Babalola. The title is The Changing Concept of Ownership, the Case of Managerial Revolution, sir.
What I want so that we will use the first 30 or 45 minutes before we take a third seminar paper. So next week, next lecture, we will only be able to take
Hello, can anyone hear me?
Yes.
Yes.
Okay, I want to be sure it's not my network.
No, I can't hear the lecture again.
I think the network is bad.
Please, I'm not hearing anything again. Oh,
Nobody is hearing anything.
Nobody's hearing anything.
I was thinking I'm the only one here.
Me, I can hear, oh, so maybe everybody should check his mics very well.
Go and sit down. I ain't hearing nothing.
What can you hear? Oh, yeah, tell us.
Tell us what you can hear now.
He's hearing from his ancestors.
I think you guys are using Glow and Airtel users. Me MTN users, I'm hearing clearly.
You are hearing from
Are you hearing from
ancestors? From the ancestors. Please don't have for them anymore. It's dangerous.
Are you sure he's still online?
Mary, please, can you private chat Prof and let's know what's happening?
I'm not seeing Prof. I'm not
Prof
even
is not
seeing him.
here. Can you talk to
He's
him
not here.
or privately?
I think it's better in private chatting.
Yes.
Prof is not here.
Hello, who is that? Can you hear me? Hello?
We can hear you, sir. We can hear
Can
you.
hear you, sir. We are online.
I thought it's my network. Oh.
Yeah. No.
Okay.
We're all waiting for Prof to come back.
Okay, ma. Thank you. Yeah.
You're welcome.
Are we still in class?
Good evening,
Yes,
sir.
sir. We are still in class, sir.
Yes, sir. We are
Okay.
still in class, sir.
Okay, let's take. Well, you won't have as much time as the other people had, though. Do
Okay,
you
sir.
understand?
Yes, sir.
In 30 minutes, sum up what you want to say.
Okay, sir.
Uh,
Yes, sir. I don't know. Other group members, are you in class?
Yes, we are.
Yes, yes, we are.
Okay, sir. So I'm going to hand over to Temitope. She's the one presenting, sir.
Okay, thank you very much, Oluwatosin. Good evening, Prof. Good evening, colleagues. My name is Temitope Ologuntoye.
are you all present? Are you all?
Yes, Prof, we are. Good
Yes,
evening,
Prof. We
Prof.
are present, sir. My own name is
And how many
Oluwatosin
of you are
Adebowun.
presenting?
We are 4 in the group, sir, but only one person is presenting, sir.
Okay.
Yes, sir.
Yes.
Does that mean the person who wrote the paper for you, Abby?
No,
No,
sir, no,
sir.
sir.
We
That's
were
not.
And
3,
this
sir.
is
We
group
all.
2 that is talking, no, not group 1, group 2.
This is group 2, sir.
No,
So
group
the
one.
3.
Group
No,
one,
Prof
none
is
of them
talking about
spoke
group
now.
1. He wants group 1 to finish their paper, then he will talk about it.
No,
Oh, okay.
group one. We want group 2 to take so that we talk about the 2 papers next week.
Okay, sir. Okay, sir.
Okay, sir. We are 4 in group 2, sir, but the 3 of us worked on it, and then the last person joined late, so the person is the one presenting, sir.
Okay.
So it's more or less like a collaboration between all of us, sir.
Yes, sir.
We have only 30 minutes. What is
All right.
what is managerial revolution, and how does it establish the view that ownership concept changes over time?
All right, sir.
So you
Thank you
have
very much.
started.
All right, sir. Thank you very much, sir. The topic having been said by Prof himself, I'll just go on to the abstract and run through our papers. So the evolution of the concept of ownership traditionally was rooted in classical legal theory as the absolute right to possess, use, and dispose of property. And this concept of ownership has undergone a significant transformation in modern legal and corporate contexts. So our paper looks at the implication of managerial revolution as articulated by James Bonham on jurisprudential understanding of ownership. It argues that separation of legal ownership from effective control in large corporations challenges foundational principle of property law, particularly the notion of ownership as dominion. By examining how power has shifted from shareholders to professional managers, the paper interrogates the adequacy of existing legal constructs in capturing the realities of corporate governance and control. Drawing on the legal realist, the institutionality perspective, and the study situates the phenomenon within broader debate in legal theory. So I'll just move on to the part one. Part one talks about the concept of ownership, and I won't be dwelling much on it because group one had done a lot of detailing with respect to ownership. Ownership is a fundamental juristic concept. In common law, we have ownership is seen as a complex legal concept that dates way back to ancient Roman law. Also, it talks about ownership and possession, having the Latin or the Roman word for it as dominion and possessio. So I wouldn't want to talk so much on ownership since group one had talked too much on it. When we talk of ownership, we think of right to enjoy property, the right to exclude other from using such a property, the right to dispose of the property, the right to manage the property, the right to the income generated out of the property. Also, the as earlier mentioned by Group 1, we have scholars who had described or defined ownership. We have Hilbert, we have Moreland, we have Austin, we have criticisms on these scholars' definition. We have Salmon, we have Duguid, we have as many as we can. We have characteristics of ownership that talks about whether it can be absolute or restricted. Also, the owner having the right to lease out the property or mortgage it, the possibility of restraining other people on it, also having government demands on tax. For some instances, you have a government generating tax even from ownership of property. We also have mode of acquisition of ownership. All these are entailed in our part 1. Types of ownership, as mentioned earlier, we have the corporeal, we have the incorporeal, we have sole ownership and co-ownership, we have legal ownership and equitable ownership, we have trust ownership and beneficial ownership, we have absolute ownership and limited ownership. We also have vested ownership and contingent ownership. So I will just round up part 1 with talking about the importance of ownership in the modern world. Ownership is a very important concept in modern world, as it is about to measure the wealth and social position of people. Ownership is a social concept and shows how one should use their rights and interests in compatibility to the interests and rights borne by the other members of the society. Concept of ownership in corporation. A corporation is, at least in theory, owned and controlled by its member. In joint stock companies, the members are known as shareholders, and each of their shares in the ownership, control, profit of the corporation is determined by the portion of the shares in the company that they hold. That is, a corporation as an entity of its own is owned by members, like members subscribing to it through shares, and the measures of their shares are being measured as proportionate to their profits, as proportionate to their control and the ownership of the company. Historically, corporations were created by charter granted by government. Today, corporations are usually registered with the state, the province, or the national government, and regulated by the laws which enacted or that enacted by governments. The registration of a corporation is a prerequisite to its existence. So it's as good as saying that an assumption of a corporation is basically on its registration. Generally, a corporation files articles of incorporation with government, laying out the general nature of the corporation. I believe we are very much known to what a corporation is. That will take me to part 2 of our paper, which talks about the managerial revolution and theories. The managerial revolution represents a reflective shift in the governance and ownership of corporation, wherein control passes from individual to concentrated owners, then to professional managers. The concept of ownership in modern capitalist economies has undergone a profound transformation, most notably through what has been termed as the managerial revolution. That's the phenomenon in itself is classically explored by Adolf A. Bell and Gardner C. Means. That's Gardner Means and Adolf Bell. In the modern corporation and private property, it refers to the separation of ownership from control. In large-scale corporation, traditionally, ownership implied direct control over the operations and decision of a firm. However, the emergence of these widely held public companies linked has been diluted. In this context, ownership is dispersed among thousands of shareholders who typically lack the capacity or insensitive to engage in active governance of the corporation. So the concept of managerial revolution in itself describes a transformation in which ownership becomes increasingly dispersed among a large numbers of shareholders, while control is consolidated in the hands of professional managers who may not hold significant ownership. What this is saying is that ownership is to the shareholders, while control has now shifted to the delegated professional managers, which we in another time could call the directors of corporations. Adobel and Gardner Means observed that in modern corporation, especially in the United States, the typical shareholder holds too small a stake to exercise effective control. Instead, managers who may not be significant owners acquire decision-making power. So it's as good as saying that these delegated professional managers has more control, has an effective control on corporations rather than the shareholders, the typical shareholders who have more ownership of the corporation. While Ll.M means analyze the implications of this shift within corporate structures, a broader concept of managerial revolution was later developed by James Bonner. In a seminar in 1941, The Managerial Revolution, What is Happening in the World, Bonner offered a radical reinterpretation of the 20th century social and political revolution. He argued that traditional capitalism proletarian classes were being displaced by a new ruling class, that's the managers and the technocrats, who increasingly dominated the structure of power both in capitalist and socialist society. The arguments could be summarized and expanded as follows. Now we have the decline classical capitalism. His argument here is that capitalism as a system is inherently riddled with internal contradiction it cannot resolve, such as inequality, secular crisis, and the inefficiency of fragmented ownership. According to Bonner, these contradictions have led to the erosions of capitalist class control over economic and political life. The second one is the impossibility of socialism. In contrast to Marx's predictions, Bonham argues that socialism, the democratic or the proletariat control of means of production, is not only unachievable in the current historical context, but fundamentally unrealistic as a future model. He views socialism as theoretical abstraction, lacking the practical mechanism or historical momentum to be realized rather. Instead of the working class seizing power, Bonham contends that the new class of managers, the technical experts, the bureaucrats, the administrators, and the corporate executive are the emerging dominant force in corporation. The third one is the rise of the managerial class. Nicole Bonham's theory is that the world is witnessing an emergence of new socioeconomic order. Hence, this transformation, which it dates to the aftermath of World War I, involves the systemic transfer of control from capital owners to professional managers. In both the private and public sectors, the operational authority once held by entrepreneurs and financier is now exercised by technically trained elites who oversees productions, planning, and administrations of corporations. In context of jurisprudence and legal theory, Bonham's thesis challenges the traditional notions of ownership, sovereignty, and authority. It calls into question the legal fictions that equate ownership with control, particularly within the corporate law, and urge a re-evaluation of how power is conceptualized and distributed in modern society. The managerial revolution signals a divergence between formal legal rights and the practical control, highlighting the need for legal theory to adapt to evolving institutional realities. Now, we are looking at separation of ownership and control in itself. In the 19th century, when capitalism was fully achieved or fully enforced, capitalists were, according to Bonham's definition, the ruling class. They control both means of production and the preferential distribution of resulting products. As early as 1900, due to growth of organization and the increasing complexity of production techniques, individual capitalist owners began handing the management of their businesses over to hired managers. That is, trained personnel, thereby losing the direct control over the means of their production. The organization now passes from individual ownership to ownership by large and publicly financed corporations. Shareholders invested the capital, the managers run the corporation. So it's now a thing of, okay, the owners, the shareholders, they're investing in it, while the professional elites, the managers, just run the organization of the company. So the control is literally in the hands of professional managers. The divorce of ownership and control has remained a fundamental element of corporate governance since 1932. The extent to which the phenomenon had spread throughout the Western corporate world by 1932 and exists to date has been recently argued in literatures. While a complete divorce of ownership and control in the US public companies has never occurred, the phenomenon itself does exist rather, and the way organizations are run has changed since the advent of the 20th century. Burnham saw the divorce of ownership and control as one of the telling signs of transition to managerial society. While American capitalists still owned the means of production, it was their managers who had the actual control over how and when those means of production were used. Power lay with those in control. At the time of writing, Burnham had held that managers and their bureaucratic military colleagues were already the powerful class in Russia, where everything was owned by the state. In Germany, managers held the majority of control over means of production and the world effective power. Hence, in both countries cited, had progressed significantly along the road to managerial society. For Burnham, however, it was just a matter of time until the means of production came under the state of ownership and managers controlled distribution as well. This will move us to theoretical foundation and case studies. The first theoretical foundation we are looking at is the agency theory. This theory was developed by Michael Jennings and Williams McLean. Agency theory examined the relationship between principal, that's the owners, the shareholders, and agents, that's the professional managers. It posits that managers as agents may pursue their own interests rather than maximizing the shareholders' value. This is another way of saying that being that the professional managers are in full control of the day-to-day runnings of a corporation, they may seek their own interests over the interests of owners and shareholders of a company or a corporation. This discrepancy creates the agency cost, including monitoring expenses, bonding cost, and residual losses. Effective corporate governance mechanisms are necessary to align managerial actions with other shareholders' interests. Looking at time, I will move to the next theory. The next theory is stewardship theory. In contrast, stewardship theory argues that managers are trustworthy stewards who prioritize the organization's long-term success. Now, stewardship theory is positing the professional managers as steward of the company and not the owners. So, in other words, it's saying that the people who are in control, that's the professional manager, seeks the interest of the company and not the interest of the individual owners of the company. They are motivated by the intrinsic rewards such as the professional reputation, a sense of responsibility, and alignment with organizational goals. A contemporary example is the Amazon under Jeff Bezos. The third theory here is resource dependence and power theories. Resource dependence theory is developed by Jeffrey Pfeffer and Gerard Slanek. I'm sorry if I didn't pronounce that well. Posits that managers accumulate power by controlling access to essential resources, capital, talent, technology, and external relationship. In the context of the managerial revolution, control is not only about ownership, but about navigating and influencing external dependency. Managers can establish themselves, shape strategy, and extend their influence over corporate direction. A vivid illustration is the Telsa and Elon Musk. Despite Telsa disease past
Are you
and variable personal stakes,
There's no
his
way I didn't look for it.
technological vision, brand, and public relations confers substantial rather power. The next subtopic here says the implication of the managerial evolution. We have number one as the accountability gap. So there's this gap of the professional managers being accountable to. So can I go on?
Go on.
All right, sir. So we have accountability gap. We have the corporate governance evolution. This talks about the mechanisms such as the independent boards, shareholders' activity. We have regulatory framework, and so on. We also have changing notions of ownership. Ownership is increasingly seen not just in terms of legal rights, but as a residual claim on corporate profits and assets. The managerial revolution has fundamentally transformed corporate ownership and control. Theories such as agency theory, like we've mentioned above, had help understand the modern corporate dynamics. These case studies highlight both opportunities and risks arising from the separation of ownership and control, necessitating the effective governance mechanism to balance interest and ensure accountability. Now we move on to comparison between classical and modern management theories. Classical management theories focuses on efficiency, control, hierarchy as the essential elements of management. We have authors like Frederick, who propose that scientific management emphasizing task specialization, time and motion studies, and strict supervisory control optimize productivity. We have Fayol develop administrative theory, outlining the principles such as division of labor, unity of command. We have Max Weber, who introduced the bureaucratic model, advocating formal rules, hierarchical structure, and impersonal relationship to ensure organizational efficiency. The modern theory is influenced by managerial revolution, ushered in a paradigm shift wherein ownership and control became separated, and professional managers gained dominance. The shift prompted modern theoretical developments, which we have authors like Bell and Means, who argue in the modern corporation and private property that this part corporate ownership weakens direct control by shareholders, giving managers significant autonomy and raising agency problem. Afrechanda in The Visible and emphasized that professional managers, rather than market force, now coordinate complex business enterprise, heralding the rise of internal administrative hierarchies. James and Meckins introduced agency theory, highlighting conflict and interest between owners and managers, proposing monitoring mechanism and incentive alignment. At this point, we made mention of key points of comparison. So looking at the aspect of control structure, under the classical theory, we have it centralized, it is owner-driven, while under managerial revolution, it is decentralized and it is managerial control. For primary focuses, we have the efficiency and productivity for classical theories, while under the managerial revolution, we have the governance, power, dynamism, agency issue. For organizational model, we have under classical theory, bureaucracy and hierarchy. For managerial revolution, we have multi-divisional corporations. Power base under classic theory, we have owners and shareholders. The power base is in the managers and administrators for the managerial revolution. Lastly, for accountability, we have under the classical theories, we have ownership, we have direct owner control, while under managerial revolution, we have potential agency conflicts. Cultural shift, there's formal authority emphasized under the classical theories, and under managerial revolution, it gives rise to managerialism. So comparing classical and modern theories reveals that managerial revolution fundamentally altered the governance of organization. Classical theory prioritizes efficiency and direct control, while modern perspective highlights the managerial autonomy, governance complexity, and agent problem. Part 3 talks about juxtaposing the concept of ownership and managerial control, a comparative analysis. In that regard, we say that the juxtaposition of traditional concepts of ownership with the dynamics introduced by managerial revolution reveals a critical shift in corporate governance. This is me summarizing. Hello, please, can we still hear me?
Yes, please.
Sorry.
Come on.
Yes, please.
Yes, we can hear you.
Don't conclude.
Okay, sir.
We
So
can
the juxtaposition of the traditional concept of ownership with its dynamics introduced the managerial revolution. Traditional ownership connoted both residual claim and control of shareholders as the owner. But the managerial revolution, particularly as theorized by Bell, means disrupted this assumption and emphasized the separation of ownership and control. So a comparative analysis across jurisdictions such as US, the UK, Germany, Nigeria inclusive, shows that institutional and legal framework mediate the consequences of this separation. In Anglo-American system, characterized by disparate shareholding and tension between ownership and control is more pronounced, necessitating a stronger governance between ownership and control, between governance mechanism rather. Conversely, in coordinated markets, economy like Germany has this concentrated ownership and stakeholder-oriented models. So, pardon me, I'm trying to round up our part here. So we made mentions of corporate restructuring and privatization. Although we have referred to these changes as managerial revolution, the changes in China, one of the countries we talked about, are gradual and evolutionary compared with other transitional economies. In conclusion, we state here that the evolution of the concept of ownership from its classical legal foundation to its modern interpretation in corporate governance reveals a fundamental transformation in how control and accountability are structured into today's complex organizational landscape. The study has traced this journey beginning with definition characteristics up to the point where we are to central on the contemporary debate of managerial revolution, which has significantly redefined the traditional nexus between ownership and control. The separation of ownership and control poses both opportunity and risks. One on one hand, it allows for specialized managerial expertise and potential greater efficiency. On the other hand, it creates a misalignment of incentives, which can lead to managerial optimism or inefficiency without proper oversight mechanism. We've also made some recommendations here. Number one of our recommendation is to strengthen the institutional enforcement, like regulatory bodies such as the SEC, the CAC, that's a Security and Exchange Commission, Corporate and Affairs, must be empowered and resourced to enforce corporate governance standard effectively. Legal penalties should be incorporated and effected for breaches. Also, number two, we mentioned promote ownership diversification, policy encouraging the listing of family-owned and state-owned enterprise, incentivizing equity participation through employee share scheme. Number three, we mentioned enhanced board interdependence and professionalism. Number four, we mentioned encourage shareholders activism. Then for five, we say we should foster ethical corporate culture, leverage technology for transparency. And lastly, we mentioned that building a long-term stakeholder model, such as companies should be encouraged to balance the interests of shareholders with those of employees. Corporate society responsibility initiatives should also be aligned with long-term strategic goals and governance. In conclusion, the changing landscape of ownership and corporate control demands continuous reflection, adaptation, and policy innovations. By fostering a balance between ownership rights and managerial autonomy, organization can navigate the challenges of modern capitalism while upholding efficiency, integrity, and accountability. Thank you.
Thank you very much. Just on the nick of time, 3 minutes to 7. We have listened to the two groups. Let's review their papers again and spend some 1 hour to discuss the two papers before we move to the third seminar paper next week. Next week's lecture should be physical. Do we agree? Hello?
Yes, Prof.
Hi.
Yes, sir.
We're attending
Yes, sir.
physical next week. Okay. So see you next week.
As the court pleases.
Thank you, sir.
Thank you, sir.
Thank you, sir.
You're welcome.
Thank you, sir.
Thank you, sir.
Thank you.
Free taking attendance, so we can log out.
If you've written your name, you can listen, then you can go. It's recorded, and the LLM will take note of it.
Okay, just to be very sure. Thank you.